law of negligence is very much a state-oriented kind of thing. It is state law, and that law could be done or could be expressed by the courts or in legislative statutes. Sure, there are occasional federal implications, but for the most part, tort law, negligence law is state law. And while you can sue in federal court in a diversity case where there is the requisite amount of damages in issue, and that has changed over the years, now it's $75,000, while you can sue in federal court, you may be surprised to learn that the federal court applies what we call the substantive law of the state in which it sits. It has its own rules, the federal court, its own rules of evidence and procedure, but the actual law of negligence and associated concepts are based upon what the state law is. That way a plaintiff wouldn't be able to forum shop, wouldn't be able to choose more favorable laws in the federal court than the state court. So we have sets of state laws in the 50 states for tort law. And it's basically not at all a federal concept or a federal legal framework. And one way to bring this home is that in my entire 800-page first-year law torts book, torts case book, I think there was only one federal case of all of the hundreds of cases that we read to learn about tort law. All the rest were state cases. And what was that federal case? That federal case involved a suit for personal injuries by servicemen in Vietnam when it was discovered that the Agent Orange was used. And they sued the Secretary of Defense, who was then Melvin Laird. And it was a class of plaintiffs versus Melvin Laird. And the U.S. Supreme Court entered its decision. There's no need for me to go into the decision. To me, the more relevant thing is that out of an 800-page case book, there was one and only one federal court case that had come about. So if you compare that, however, that concept, all these tort cases, these negligence cases, to something like criminal procedure, you would find a vast difference because most of the criminal procedure cases are U.S. Supreme Court cases. That's the body that pronounces the law on all those crucial amendments we hear about, the 13th, 14th, especially the 14th Amendment, due process, equal protection under the law. The 15th Amendment is voting rights, and various other amendments. But the one to bring to the discussion is certainly the 14th Amendment. So while a torts book may have one federal case out of 800 pages, in contrast, a criminal procedure book may have 500 to 700 out of 800 pages of federal and, in fact, U.S. Supreme Court cases. And that is because constitutional issues are interpreted in the latter, that is, in the latter group of cases, the criminal cases, especially criminal procedure, whereas in tort cases, it is not a constitutional issue. It is a matter of the substantive law in the 50 states, in each of those 50 states. Thank you.